5 minutes.
I do. Thank you, Your Honor.
Okay, please proceed.
Thank you. George Vaca on behalf of Macbeth and Jenny Collins. Just some brief background about this claim in this case. My clients live in Everglades City, Florida, and their home was damaged by Hurricane Irma back in September of 2017. That loss was timely reported to the homeowner's insurer, Avatar, who sent an adjuster out to the property on October 26th of 2017, which happened to be the same day that the client's PA submitted a repair estimate, a detailed repair estimate of $109,184.80. Avatar, a couple of days later, on October 31st, sent a roofing inspector, and 2 weeks later, they sent a letter enclosing the roofer's estimate, informing the clients that the estimated repair costs did exceed their deductible, and that after having applied that deductible, Avatar only owed them $8,095 and included a check for that amount. Our clients filed suit in March of 2018, and rather than answer, Avatar first filed a motion to dismiss for having failed to attach the contract, and then thereafter they filed a motion for summary judgment, in which they raised the lost payment provision of the policy, claiming that no benefits were due under the policy and that the insured had filed suit prematurely under that provision.
Mr. Vaca, can I interrupt you for a second?
Yes.
Because I have a question about the facts, and this is something that's been distracting me as I read the facts, and maybe it's just the way that this got written, or maybe there's a method to why it's laid out the way it is. But as I understand it, the Collins inspector went out, and the day that he was out there, there was someone from Avatar. And then on the same day, I think that was the 26th, the inspector sent to Avatar his estimate.
Correct.
And then it wasn't until, that was like on the 26th. And then in November, Avatar sends their letter with their estimate and the check. Is that the right sequence?
Yes.
Okay, here's what's bothering me. In your brief, you lay it out differently. In I think even in the complaint or in the response to the most, it's always Avatar sent this check in November. We sent our estimate in October. Why? It's bugging me that it's in reverse order. And is there a significance to that?
Maybe I'm misunderstanding your question. I don't think there's any doubt that the estimate was sent on October 26th. I think that is in
right, but in telling the story, you've reversed the order of events. You always, or maybe it's in the complaint or the motion, but it's also in the brief. You talk about Avatar sends out their check and their estimate in November. And then you go back to it in October, we sent our estimate. And maybe it's not that way in the brief. Maybe it's just that way in the complaint and in the motion and the response. But I was just curious if there was any significance to reversing the order of events.
If I did it, there certainly was no significance to it. It would have
okay.
been.
Because to me, I'm thinking, well, you know, if you sent your 107 or whatever $1,000 estimate on the 26th, and the response from Avatar is, okay, here's your 17,000. That's a different story to me than they sent us 17,000 and then we sent them 106.
No, I mean, I went through the entire record again this weekend. The notes that I took from that was the sequence that I just related to, Your Honor. So Your Honor would.
Yeah, well, and everything bears that out, but there's a couple of places where that sequence is reversed. And I just didn't know if there was any legal significance or any strategy behind reversing it, or somebody just, that was the order they wanted to tell it in.
I can.
Mr. Vaca, if I could ask you a question about the summary judgment. The
Yes,
summary judgment motion was granted because Avatar convinced the judge that there was no duty of payment at the time the lawsuit was filed, and therefore there was no basis for the lawsuit. And there's a case, Skeen versus Avatar, which you all have cited. Everybody knows about it. It seems to have very similar facts to this case. And it doesn't seem like that this case was decided based on the rationale in Avatar. It also concerns me that you've made this argument, but and as I read insurance policies, I always want to make sure I read them as a whole and kind of catch everything. But it seems clear to me from this policy that there was no requirement to submit a proof of loss until the insurance company asked for it. Is that right?
Yes, Your Honor. That's
Okay.
that's in the duties. That's in the duties after loss provision of the policy. And in their answer brief, Affidar has taken the position that we shouldn't read that because they didn't put that at issue. And as Your Honor might recall from reading the response to the motion for summary judgment, the third district's decision in First Home Insurance versus Floorman, which is at 36 Southern 3rd 172, was cited in the response. And let me just tell you what the third district had to say about a similar situation. The court said there, the insurer also contends the insured failed to file a timely proof of loss. This argument is without merit. The insurance policy requires the filing of a sworn proof of loss within 60 days after the insurance company requests it. The insurance company never requested a sworn proof of loss prior to suit being filed. And
Yeah,
so
I don't. Go ahead. I'm sorry.
I see no meaningful difference between what the third district said in that case when it was observing the policy from First Home Insurance Company and this case. It's undisputed that Avatar never requested a proof of loss, and therefore the client never submitted one. And that's not a fact that's in dispute. I think, I mean, the court, we've cited the court to the Curtis case and to the Skeen case, what's the other case, the bio case that Judge Badalamenti wrote when he was here, BioServe. I think it's quite clear that this summary judgment is wrong on the merits. This summary judgment motion, we've cited the court to the actual Westlaw citation of the motion for summary judgment in Skeen, upon which that judgment was based and then reversed by this court. There is no meaningful difference between that motion and this one. It cites the very same provision in the policy, and then it goes the same way that this motion for summary judgment did as well, which is policy specifies exactly when payment is owed and when it is not. The terms are clear and unambiguous. Before payment is owed, there must be the submission of a sworn proof of loss, the passage of 20 days after the submission of a proof of loss, and a written agreement, and he goes through the entirety of the loss payment provision. And I don't want to get too far off the merits because I think we so clearly were wronged by this summary judgment on the merits. But there's some other things I can't help but at least to bring up to the court's attention. There was a case by this court involving Avatar again called Rodriguez, in which the court was very critical of the affidavit that was crafted by Avatar's lawyers and submitted in support of that motion. This one, and then there's also—
Was that the 40+ paragraph affidavit?
Yeah, it was an affidavit that basically was a cut and paste of the motion for summary judgment.
Oh, which is what they did here.
And which the 5th District, likewise, in March of this year, criticized Avatar again for doing.
Well, they didn't even admit that these people owned the property.
And then we go beyond that, right? So now we're at a hearing. It's Mr. Homan who works with Mr. Allen. Mr. Homan is one of the lawyers in the Skeen case. Mr. Homan is one of the lawyers in the Curtis case. Mr. Holman's one of the lawyers in the Rodrigo case, which is the one that they relied upon that didn't have the provision. That one had mandatory submission of a proof of loss, not optional, with the option of the insurance company. They didn't disclose the Skeen case to the court. They didn't disclose Curtis to the court. And it's clearly controlling authority. It's not my place to criticize colleagues on the bench, but they shouldn't benefit from that behavior, which clearly the rules regulating the Florida bar say is improper. So I think the court understands my argument perfectly. This summary judgment was erroneous from the get-go. And I would ask that the court reverse it with directions for the court to conduct a trial on the issue of what is the amount of our client's damages, since Avatar has admitted that it's never denied coverage. If the court has no questions for me, I'll save whatever time I have left for rebuttal, please.
Thank you. You'll have 5 minutes, even though you've not used all that, but that's all we allow is 5, okay?
Thank you.
All right. Mr. Lima? You've got some
Morning, Mayor.
explaining to do here, you know?
Yeah, Mr. Lima, you really do.
And we know
I'll
you
tell you
wasn't
up
you,
front.
so we're not laying this at your doorstep, but things don't look real good at the moment, so help us understand it.
I appreciate that, Your Honors. I'd like to sort of focus on the merits of the legal argument, which is, I think a close question, without getting into, discussing what, throwing shade on trial lawyers below what they did or did not do. The issue before the court is whether the summary judgment was properly granted. And our position here is fairly
Well,
simple.
let me just, and apologize, but we do have these cases, Curtis versus Tower Hill and Skeen versus Avatar, which you are very well acquainted with. You fully briefed them, and so has your opponent. Did this court's ruling, was it based on those cases?
It was not, I don't think it was, Your Honor, and the reason for that is very important. The reason for that is it was never brought up by plaintiff's counsel below. And again, I'll point out, obviously, it was not Mr. Vaca or his firm, but the plaintiffs were represented by very experienced first-party property insurance lawyers.
Well, Mr. Lima, I'm going to stop you because I read the hearing transcript and I read the response, and the issues that are being raised on appeal were raised in the trial court. Okay, the same arguments. You don't necessarily have to cite the same cases, but those arguments were made. So, I echo Judge Morris. And this isn't throwing shade on counsel to say that this is the legal argument that Avatar presented below and here, to me, is very difficult to defend. So we're giving you the chance to do that.
I appreciate that, Your Honor. I'll respectfully disagree that the exact same arguments were raised below. I understand, obviously, you don't have to cite the specific cases. They didn't cite Curtis, they didn't cite Skeen. That necessarily is not fatal. But if we look at what they did argue, they set out very clearly at page 827 of the record, that's their motion for summary judgment. They say the court should deny the motion for 4 reasons. First, Avatar did not request a sworn proof of loss from Collins. Second, Avatar breached the policy by failing to initially pay the actual cash value of the loss. Third, Avatar waived its right to require a sworn proof of loss. And fourth, Avatar failed to provide the Collins with a form proof of loss to complete. That's very different from the argument here, which, again, Mr. Vaca's firm has very artfully set out and articulated, which is that the loss payment provision did not render the suit premature.
That was the basis of your motion for summary judgment, was that no payment was due, and those 4 items that you just articulated was the response to why payment was due, why that no payment is due argument was flawed.
Well, the no payment due argument in this case is slightly different from what it was in Curtis and Skeen. In Curtis, well, actually, Skeen didn't really get into that aspect of it, but Curtis did address it. And in Curtis, it really focused on whether the portion of the loss payment provision that requires a final judgment. And obviously, we would agree that it doesn't really make sense to argue that you can't bring suit until you have a final judgment. You can't put the cart before the horse. But what the court wrote was that the loss payment provision of the policy did not render the suit premature. Indeed, that provision expressly contemplated that there might be a final judgment, presumably stemming from a lawsuit before payment was due. Our position here is not the absence of a final judgment or an appraisal award, but rather because those are elements that are completely outside of the plaintiff's control, and understandably, they can't be penalized for not doing something that they
I'm
can't.
sorry, Mr. Lean, I'm interrupting you.
Sure.
Fundamentally, what Skeen and Curtis stand for that I think is relevant here is that in each of those cases, the insurer has admitted coverage. And here, Avatar admitted coverage. And for that reason, the suit, that putting aside all the loss payment, timing, and mechanics, it would be legal error to grant summary judgment for the insurer on those facts. And that's, I think, what we have to confront here that is very problematic for your side of this case.
So I think what Your Honor is getting at then, Judge LaBritte, is the remedy. And here again, that's another issue that simply was not raised by plaintiff's counsel below until rehearing.
Well, they argued it in their motion for rehearing, and you acknowledge in your brief that
Yes.
that's at least a debatable proposition, and we're on a de novo review. And so let's assume that this issue was preserved and properly presented to the trial court for purposes of our review. In this case, there's no technical problem there. And under those lights, I don't see how we get away from, or how you get away from Skeen and Curtis. It just.
Well, and that's what I was starting to explain, the distinction between Curtis. Again, Skeen really concerns more just the remedy, but Curtis focused on the absence of a final judgment outside the plaintiff's control. Here, there is the sworn proof of loss, which indisputably was never submitted by the plaintiffs. And there was some discussion in Mr. Vaca's presentation about it not being requested by Avatar. That's absolutely correct. It was not requested. But the distinction there is that, and the Florimond case that he discussed also talked about the need to request a sworn proof of loss. But there are importantly two different provisions in the policy that reference sworn proof of loss. Under these your duties after loss requirement, which is at page 497 of the record, that Mr. Vaca is correct. You need the plaintiff need only submit it within 60 days after our request, a signed sworn proof of loss. But if you take a look at the provision that was placed in issue below and here on appeal, it's the loss payment provision, completely different portion of the policy. And it says that losses will be payable 60 days after we receive your proof of loss. And you have to read the policy as they're written. Obviously, you have to give effect to the various provisions. There is a requirement for a request in one portion of it, not in the other portion. And here again,
yeah, because I think they're assuming you requested it and got it, and that starts a clock running. I don't find it persuasive, just to tell you, put my cards on the table, to say that you look at the loss payable clause, and because it references a receipt of a proof of loss, that somehow that creates an obligation for them to submit one if you haven't asked for it.
I understand and appreciate Your Honor's position. Again, we would disagree that they're factually an important distinction here again is this is not.
I mean, isn't this case really about Avatar thinks this loss was for one amount and the appellants think it was for another amount, and somehow that's got to get sorted out? I mean, you admitted that there was coverage. You made a payment in an amount they disputed, so they sued you over the difference. So why are why? I don't understand really what even the strategy for Avatar in this case.
And I can't speak to that, obviously not being involved until the appeal, but I mean, I think the strategy is there is a difference as to the amount that's payable. Coverage has been admitted. However, there's a time, the policy sets forth a time for when payment is due.
Okay, so what do they have to do to get paid?
What they have to do,
You're saying Avatar will just pony up the rest of that money? If they just do X, Y, or Z, so what do they have to do to get it?
I can't say that they'll pony up the money immediately, but what I can say is
Any money. What do they have to do to get some more money?
I think they would have to submit the proof of loss as stated in the loss payment provision, and
So
then
they got to send what they already sent, but swear to it.
well, and that is a very important distinction, Your Honor. As your Honor knows, the sworn proof of loss provision comes.
No, but I'm
with
just
a-
trying to understand what Avatar wants. What do they want from these people?
Well, the sworn proof is an important document. and-
Okay, what else do they need to do to get their money?
Well, I can't speak for, the claim adjustment process, but that's the threshold here.
No,
that they
okay,
need
what else do they need to do to file suit then?
To file suit would be to comply with all of the pre-suit obligations.
Which is,
Submission of a sworn proof of loss.
which you didn't
Um,
ask for.
We did not, Your Honor.
Okay, what else would they need to do to file this lawsuit?
Well, they have already submitted an estimate for the amount.
Right?
And, at this
What do
point,
they need to do to file a lawsuit as far as Avatar is concerned? What else do they need to do? Because like if you prevail, they're going to be back to the drawing board figuring out how to file this lawsuit. So what is your position?
well, and that gets to the remedy. I think the correct remedy, if it's not to affirm the summary judgment, would be to find that, okay, plaintiffs, you are not barred as a matter of law from recovering. Will remand for dismissal without prejudice and submission of the sworn proof of loss, at which point the claims adjustment process can proceed. And at that point, the policy sort of takes over. We get the sworn proof of loss. Avatar can either make the decision to pay the amount that's sworn to. They can invoke the appraisal provision, which.
Well, if Avatar wanted a sworn proof of loss, they could have asked for it,
They could have.
but they didn't, and they made a payment. And that goes, I think, to the waiver argument, if I'm remembering correctly. What about that?
Well, their waiver argument was actually that the claim was denied rather than that coverage was acknowledged. It was actually the opposite. And here, as Your Honor's pointed out, and we're certainly not disputing, there was no denial of coverage. There was an acknowledgement of coverage and a partial payment. And so, again, I think the remedy at minimum would be to allow the claims process to draw out to conclude. At which point we have an amount of loss dispute, we can go to appraisal, or perhaps Avatar would acknowledge additional coverage and reach some sort of a mediated settlement. But there is, at this point, we're just asking the court to enforce the provisions of the policy as written and affirm the judgment.
Okay.
And unless the court has any further questions, that's it.
No.
Okay, thank you, sir.
Thank you, Your Honor.
Mr. Vaca, you've got 5 minutes, sir.
And I'll hopefully not take all of that. I think my colleague has kind of ducked really one of the burdens that his client had to get the summary judgment under these circumstances. So I pointed out that they didn't file an answer. They filed a motion for summary judgment, and that's a heightened burden of proof. They had to show and establish conclusively and to a certainty that my clients could not plead or otherwise raise a material issue of fact. So they didn't satisfy that burden. They cannot ever satisfy that burden under these sets of facts. Mr. Lima also, Your Honor, Judge Kelly, you asked what was their strategy, and I've got 2 answers to that. Mr. Lima kind of let one of those go just a moment when you were asking him some questions where he said, we can draw out the process. That's part of what this is about. The other part of the strategy, Your Honor, is to take a look at all those exhibits that Mr. Allen and Mr. Holman filed with their motion for summary judgment or just prior to the hearing. That's what their strategy is. They get judge after judge after judge to buy this argument, or as the 5th District recently pointed out with Mr. Allen, when he goes through the adjustment process and takes examinations under oath for multiple days, that's what the process is. It's to win. It's not to do the right thing. It's to win. And those exhibits document that that's the strategy. So I would ask the court not to accept that for one bit. What happened here was wrong. It was wrong for a lot of reasons. I don't need to go through it all again. And we would ask that the court reverse this summary judgment and remand it for a trial on the merits. Thank you.
Thank you both very much. It was well argued. And Mr. Lemmy, you did a particularly good job in defending the lawyers in your firm who maybe should have been here to explain it themselves. But thank you. Have
Yeah.
a good day, John.
right.
Thank you, Your Honors. Have a good day.
Thank you.
Our next case would be Mary Jo Futch versus Estate of Alvin